There's an unprecedented fight that has erupted between the Ghana Bar Association and its leader, the Attorney General. The Ghana Bar Association, remember, 3 days ago, sat together at this mid-year conference and adopted a resolution. It is a very controversial resolution. At the time when it leaked, many said it was just speculation and that it wasn't true. In fact, I was told by senior members of the bar, the leadership level, that we should simply ignore it. And then we learned a few days later that it was in fact true that the GBA had indeed adopted a very controversial resolution, a very unprecedented one indeed. Considering what is happening already, it's already controversial and unprecedented. Their resolution was equally within that same scope. And then we were told that we should wait for the full text of the resolution. It didn't come until today. And as you can imagine, it sparked a fair bit of controversy, even among members of the GBA. And tonight we're going to tap into that. A few lawyers will join me, pick their thoughts, and let them debate their association's position on this very controversial matter. Subsequent to that, we'll also hear from the spokesperson for the Ghana Bar Association and hear from the Attorney General, all here on PM Express. But what really is at the heart of the controversy? This. When the GBA met and then decided to adopt the resolution to ask the president to revoke the suspension of the Chief Justice, you knew this was going to be one hell of a controversy, and it turned out to be so. So that was the first major decision they took, that resolution. The second thing they did is that they were not only saying that the president should revoke it, they said it was unconstitutional what he was doing. Why? Because they claim there's no constitutional instrument. There's no statutory instrument. There are no regulations backing the president's actions. But there is a constitutional provision in Article 146, which the president was referring to when the statement was issued in the decision to suspend the Chief Justice. In fact, the Council of State has former Chief Justices on it. And so very interestingly, when you see that the Bar Association is saying it's unconstitutional, it raises fundamental questions from mere mortals like ourselves. But of course, this is all pursuant to a constitutional provision. So what do you mean it is unconstitutional? Well, the GBA will be explaining to us tonight here on PM Express. Then they also say, because they believe it's unconstitutional because of the lack of clear constitutional provisions, constitutional instruments to back it, then enact rules for Article 146 procedures. But isn't the obvious question the fact that in the absence of the regulations, you can only work with what you have, the Constitution, right? We'll ask that question when we sit for a conversation. And then they also tell the president that he should release the decision backing this prima facie case that was made against the Chief Justice. Another very unprecedented demand, but they say, well, there's precedent to this. It's not unprecedented at all. It has happened before. We'll get clarity around the two when we sit for a conversation. And then 5, they also want the acting Chief Justice to withdraw the new directive he issued, because he said, in essence, in the notice that we saw last week, the acting Chief Justice, Justice Bafoboni, said, all cases must come to me for assignment. I need to assign these cases. In fact, it is the Chief Justice's prerogative to assign cases. The suspended Chief Justice did it, all Chief Justices before him did it, but the GBA says, well, you have to withdraw that directive. Why? We'll explain that. They make a very interesting point about this particular decision by the acting Chief Justice, and they say, why don't you use technology to assign the cases? Why do you want to insert yourself in there? But is the GBA worried that this possibly may be a cover to manipulate the judicial process through the assignment of cases to favorable judges? Very interesting questions for mere mortals like ourselves. We must ask them, right? And then you come to the opposition NDC. They've been speaking. Obviously, you knew this will happen. They are obviously not happy with this. They say it is what the GBA is saying is that not every presidential discretion requires the legislation, constitutional instruments to guide it. GBA is being hypocritical. They accuse them of being so. The decision to go to court. And I'm making this point about listening to go to court because, in fact, the GBA had told us today that it is a possibility that they may drag the president to court over what is happening, over the suspension of the CJ and the way the entire process has been handled. Very fascinating indeed, uncharted territory. But as you know, as I said at the beginning, the Attorney General is the leader of the bar. His office, the Deputy Attorney General to be very specific, had actually called the GBA lawless. He says the GBA's actions, the resolution that they've adopted is lawless. I asked him, are you accusing the GBA of being lawless? He says, of course, if their actions are lawless, they are lawless. That sets up this very interesting clash playing out in the public between an association and its leader. Fascinating indeed. We're going to first be talking to a few everyday lawyers that you may have not heard before, but they have views on this. 3 of them will join us. Very quickly get your views on the association's position, and then we'll hear from those in authority, both in the GBA and in the Attorney General's office. Hope to get some clarity for you as you sit to relax and understand what has happened today on this very major developing story around the Chief Justice. These are unique times, and we are all learning, and our democracy is all better for it. But we need to go through all this until we get some clarity to guide the future processes of the removal of, say, a Chief Justice in the future. This is why PMSS exists, to unpack it all after this. And thanks for staying with us here on PM Express. And my guests are joining me for a conversation tonight. 2 parts of this. I want to hear from the lawyers themselves, members of the Ghana Bar Association, and then I want to hear from the leadership of the bar itself, and then I want to hear from the Attorney General's office. And PM Express is always brought to you by Syntex Tanks. It's also brought to you by Academic Times newspaper, and brought to you by Pepsodent Cavity Fighter. Joining me right now are 3 lawyers. They are members of the Ghana Bar Association. Alfred Papadakwa is a lawyer himself. Raymond Bedema, also a lawyer. And Ni Omanyiboni Lamte is also a lawyer. And members of the Ghana Bar Association to join me right now. Post that, briefly, we'll get to hear from the spokesperson for the Ghana Bar Association, and then we'll hear from the Deputy Attorney General, because there are a lot of things to unpack. And if I'm a law student, I will be salivating over these matters because everybody has an opinion on the matter. But I want to speak to the members of the Ghana Bar Association, considering that their leader, the leader of the bar, the Attorney General, is calling the decision, the resolution of the GBA lawless. It's pitching the association against his leader. Very fascinating indeed. Let me bring in my friends who are joining me right now for this first part. And I want to start with you, Alfred, and all of them are joining me right now for conversation. You see them on your screens right now. I want to bring in Alfred. Alfred, quickly, I want to ask all of you the same question before I come to your reasoning behind where you stand on the matter. But first, Alfred, do you support the position of the bar? When I say support, the fundamental question which was posed to the members at the mid-year conference, which is, should the president revoke the suspension of the CJ because it's unconstitutional? They answered yes, and so the resolution has been passed. Do you support that resolution? All of you, please unmute for me. If you are muted, please unmute. Alfred, I want to hear from you first, very briefly. Do you back your association's position on the matter?
Even as I disagree with that position.
Okay.
And if you should ask me the basis of my disagreement,
I will actually come to that. I will want all of you to elaborate, but let me hear from Raymond. Raymond, you agree or disagree?
I strongly disagree.
So you also disagree. Ni, what about you? Please unmute for me, Ni. Okay. Whilst I get Ni to unmute, Ni, have you muted? Can I hear you? Okay. Whilst I get Ni to sort out his microphone so we can hear him, I want to hear the reasons for my two friends who join me, two lawyers who join me on this. They both disagree with the association's position on the matter. But let me start with you first. Why, though, do you disagree with the position, Raymond? Raymond first.
I disagree because I don't think it lies in the mouth of GBA to tell whether or not a thing is unconstitutional. That is the role of the Supreme Court to determine constitutionality of a matter. So if you read the case of S Party Corsa, the Supreme Court was very elaborate, very explicit on instances where a person can actually invoke the original jurisdiction of the Supreme Court in order to determine the validity of a matter. And also the Constitution itself has provided for a mechanism by which if a person feels that a thing that is done is unconstitutional, how to go about it. If you go to Article 2, Clause 1 and Article 130, you can go there for that thing or that matter for which you think it is unconstitutional to be declared. And it does not lie in the mouth of any individual or an association to determine the constitutionality of a matter.
Okay.
And so I feel again that GBA is trying to usurp the rule of the Supreme Court in this matter.
Okay, so that is Alfred's opinion. That's Raymond's opinion. Alfred, what about you? You are telling me you'd also disagree. Why?
Yeah, Evans, you see, when you look at the basis for the suspension of the CJ, you would realize that it is the president was acting under Article 14610 of the 1992 Constitution. And the president was acting upon the advice of the Council of State. Yes, what it actually means is that it was based on the advice of the Council of State. So the GBA as an organization cannot come and make a point that the president should ignore the advice of the Council of State. That is actually what the GBA is saying, that president should ignore the advice of the Council of State, which I find it very, very unfortunate. Now, number two, you would also realize that there is actually a pending application for the suspension of the order for suspension, or however you call it, at the Supreme Court. I stand to be corrected, but there is actually an application which was filed by Vincent Sifua on that matter. Now, if the GBA, which earlier on had issued a communique that we should be mindful on some of these discussions because the entire matter is sub judice. And just a few days after, the GBA, knowing very well that this matter is sub judice, comes out to now flout its own directive and make the point that the president should revoke the suspension. What it actually means is that the application now pending before the Supreme Court, which is to be heard later on in the month, has already been determined by the GBA, which is quite unfortunate coming from the Ghana Bar Association. Now, the next point that I want to raise in relation to the communique has to do with the fact that the GBA indicates that there's a constitutional instrument that has to be published before the suspension could be undertaken.
I mean, don't they have a point there? Because, and that is reference Article 296 C. It says where the person or authority is not a judge or other judicial officer, and the president in this case is neither of these two, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution. There isn't one, and so their point is this discretion is unconstitutional.
I think the GBA ought to have abated its mind on some Supreme Court decisions on this matter. It would have probably guided them in this conclusion. I mean, you look at the case of Ransford France, which I think was decided somewhere in 2012. The Electoral Commission did something similar, and it was determined by the Supreme Court. I mean, Justice Dateba and Atuguba indicated that, look, if we are to go by the fact that every administrative decision that will be taken by a public officer should be in line with the publication of a CI, then there is virtually going to be a nuclear meltdown. What that actually means is that nothing is going to take place, because basically every decision taken by the executive or administrative officer is a discretionary one. So the Supreme Court proceeded to make the point that when the person is exercising a quasi judicial matter, the person would be required to do that. So the question that I think we should ask ourselves is the advice given by the Council of State to the President to suspend the Chief Justice, is it a quasi-judicial advice or quasi-judicial matter? It has to be determined. So the GBA ought to have really taken their time before coming to this conclusion.
So that's your reasoning. I want to hear Nii. I didn't hear Nii earlier when we started the conversation. Nii, tell me, where do you stand on it? Do you support the association's position?
I completely do not support the position taken by the association. In fact,
boy. So all three members of the association that I randomly picked to join me, all of you disagree with your association. Okay, let me hear your reason.
Yes, in the first place, I believe Clause 2 of Article 146 insulates the procedure that has been provided for under that article. I mean, if a superior court of a justice of the superior court is going to be removed, or a justice of a regional tribunal is going to be removed, the procedure is strictly in accordance with the Article 146. So one wonders why people are making so much effort to import the procedure under Article 296C into Article 146. But granted that is nothing to...
But you make a point there. I mean, the Article 146, the clause that talks about the suspension, is a discretionary provision which the president exercises. That is clearly aligned with Article 296.
I agree with you. Yeah. But you see, the Article 146 itself, the premise of the Constitution are not oblivious of 296C when they provided Article 146(2). They said the procedure is restricted to 146. They are the premise of the Constitution. They have made Article 296C. And so I think they are very much aware of it when they provided Article 146(2). You get what I mean? Yeah. So my point is that the effort being made to import Article 296C into 146 is unconstitutional. But granted that is not the position of the law. Now, as my brother was saying, my learned colleague was saying, Article 296C has already been interpreted by the Supreme Court. So the GBA ought to have averted its mind to that interpretation. And I don't want to believe that the members of the GBA who gathered at the Labadi Beach Hotel and took these decisions do not know about the position of the law, the position of Article 296C, as far as the interpretation of the Supreme Court is concerned on that provision. I believe they are very much aware of it. But of course, for whatever reasons but law, they decided to take those decisions. And I think it's rather unfortunate. Okay. And it brings the entirety of the legal profession into gross disrepute.
So let me ask all of you members of the Ghana Bar Association who disagree with your association's position on the matter. Just out of curiosity, did any of you attend this media conference?
I wasn't there.
You weren't there. Raymond, you weren't there either. Alfred?
No, I couldn't attend.
But why? Isn't that the problem? Right? Because the association met. If even it's 5 members of the association who met there, they would have adopted a resolution in your names, and that is the association's position. You all disagree, but you were not there.
Yeah, Evans, I think to be honest, I start to be corrected, but I mean, the notice for me was short.
Okay.
And for a while, I've not attended mid-year, or I've not seen any. Maybe when the GBA executive comes, you may have to find out from him when was the last time a mid-year conference was organized. I'm not aware.
Okay. And Raymond, is that the same for you? You didn't go because you were not aware?
I think the notice, for me, I think the notice given was too short. I think the notice came somewhere. My notice, I received the notice of the conference on Thursday. And by that Thursday, I was out of Accra.
Okay.
So it was practically impossible for me to
You would have gone if you had advance notice. Raymond, you would have gone if you had
attended.
If you had not enough notice. Okay. And what about you, Nee? You would have gone?
Like Raymond, I saw the notice on Thursday morning, and I saw it just because I went to the offices of the GBA, and I saw the banner displayed at the gates of the offices of the GBA. So, I mean, and the information I have is that the mid-year conference is not something that usually occurs. So lots of lawyers will not avail their minds to it. But of course, I believe if I had had enough notice, I would have been there.
Okay. Is there any remedy? All of you disagree with the association to fixing this, or this is fait accompli, the decision has been taken, it is all in your names, but you disagree? Well, what's the remedy there? You simply let it go because it's of no legal effect? Maybe I should start with Alfred. Alfred, what's your take on this?
First, I think the association itself, after a few hours after the publication of this notice, I think they themselves, they've seen the kind of reaction that has come out. And I do not need to do anything. I think the association itself would have to take steps to remedy whatever they've put in the public domain. Because, like I said, what this contains is actually inconsistent with the previous statement that was issued. And if they knew they were going to have this kind of deliberations there, probably they should have waited until the mid-year review. Then probably they come out with a more reasoned communication to all of us.
Okay. Gentlemen, thank you very much. Very fascinating indeed to hear all lawyers. 3 of them disagree with the association. I'm grateful that you joined me with your quick thoughts on this. I want to bring in Xavier Kuju. I want to now get some clarity on what really happened at this particular mid-year conference of the bar. Before we even get to the specifics of the position articulated, Xavier, thanks for joining me again. Please clarify for me. You've had 3 members of the association all disagree, and they say they didn't have enough notice. Is this a usual practice? They say this is not something that regularly happens. Was this sort of an emergency call of all members to attend, or was this planned way ahead of the emergence of this controversy surrounding the Chief Justice's removal? Give me context here.
Thank you very much, and good evening, and good evening to my colleagues on the line. Let me start by saying that I will encourage, or they should make sure they are on our mailing list. Okay. And had been given about this. The only time he got to know secretariat and saw the banner. Our agent is
clearly we have a challenge with this line. It keeps,
hello?
Xavier, I can hear you. Yeah, maybe it's better. It keeps fading in and out, but yeah, let's listen.
Okay. The last time, I'm trying to park. I'm driving, so I'm trying to park when I park. The last time, if I recall, we had a media conference was in 2022 when we review our scale of. So it's a regular thing that we do. It's actually supposed to be an annual affair, but sometimes circumstances are like that. We are not able to do it. So one cannot say that it's been organized because of this topical issue that's going on. Because don't forget the suspension of the Chief Justice took place just last week. And we've been advertising this conference we had been advertising this conference for over 2 weeks before the fixed date for the conference. Now, it wasn't organized just for this. If it was just for this, I believe the communique or the resolutions we came up with wouldn't have been in respect of other subject matters, apart from this very subject matter. And again, just like any meeting that a group of people attend, when you go, many people will have various and different views. But at the end of the day, the position they create up by the meeting is what you go by. And let us also not forget that the GBA's decision-making body is the conference of the GBA, including the mini conference. So just that they have disagreed, I believe if they were there, they would have disagreed too. But should the majority of the people say that this is the position that we should take, I am not sure they would have said because they disagree, they are not going to be part of it. We are all aware of the Joseph France case.
Yeah, I'll come to that.
Many of us are aware.
I'll come to that because that is at the heart of the disagreement on the resolution. But how many members were present at this conference?
Well, I think over 200, a little over 200 people registered for the conference. Sorry, but I must admit, as at the time that the resolutions were being passed, not many people were available because it started raining. Some had to go. So not many people were available, I must admit.
Well, was it less than 50? Was it more than 50? Where would you put it?
I think it should be more than 50 because I did accounting. Those who were for the resolution were about 47, I recall, and about 5 were against, and a good number to abstain.
Okay, so 47 were for the resolution?
Yes.
And how many were against the resolution?
If I recall, I think about 5 were against and a certain number to abstain. I can't recall that number.
In your constitution, is there a subject of quorum at all for such major decisions? And is 47 and the total number there enough to form a quorum for such a big decision?
No, because what it is this. Once the conference had begun and everybody else was there, anything that goes on, because it was a process, we didn't take a break. The only time we took a break was to ask the media people to go out whilst we were doing this aspect of it. And everybody else.
Goodness, I may have lost.
Not that they had left, but they were moving around and coming in. Some people might have left too.
Okay. I mean, but that offers clarity that, out of the total that went, so 47 said yes, 5 said no, so that if you put that together, you're talking about 52. And then you said how many abstained?
That number I can't recall, but a good number.
Just abstained as far as this is concerned. So this
not everybody voted.
Not everybody voted, okay. So
and as I said, there were, just as at any other meeting, there were different shades of opinion on these issues, all the issues.
Okay.
Except that because majority said this, all of us must go by that.
Okay. Thank you very much.
I mean, those of us present.
Okay. Thank you, Sabia, for clarity. Now I understand what happened as far as this is concerned. And the conference has been advertised, said 2 weeks before it happened. Do I have the Deputy Attorney General with me? I believe he is. Do I have him? Okay. Dr. Justice Simsai is the Deputy Attorney General. We're not getting clarity about the total number of individuals who actually passed and adopted this resolution. It's 47. Does that change anything for you, knowing your association that you're a member of?
Yeah, Evans, I must thank you and your production team, and also my very good friend, Xavier, for bringing clarity and giving us the context, or giving the public the context within which this resolution was made. Clearly, GBA better in the sense that a matter of nature, which is very serious constitutional law, and which is affecting governance at the highest level, someone might have prompted, that a resolution of 45 people, which is going to be attributed to an association of over how many? We are more than 5,000 people. Should be carefully thought before it's even printed on the letterhead of the GB. However, it has happened. Like I've always said, law is not a question. It's not democracy. So that when 10,000 people say this is the law, this is the meaning of the law, and one person said this is not the meaning of the law, then the 10,000 will win. It doesn't work that way. Law is supported by legal reasoning, paying attention, legal precedents, reading text, and reading them in the light of decided cases. As my three colleagues who were on the show earlier have indicated, there is already a decision on this matter. So to pass a resolution on something which the Supreme Court has already, decided, and expect that the resolution should take precedence over the binding court decision is one thing that I cannot imagine would happen in an assembly of lawyers. Secondly, one of the resolutions, one point in the resolution says that the president should go ahead and publish the
decision, the prima facie decision, the basis for it.
When we all know that the Constitution commands that the process be done not in public, and there have been at least 3 decisions confirming that not the petition, not the conversation around it, not the content of the petition, not the process, what happened in the proceedings should be made public. So if in the light of this strong constitutional, injunction supported by decided cases, the GBA, an assembly of lawyers, can actually pass a resolution calling on the president to, as it were, make what the Constitution requires to be private public. Then again, there's a problem with that. Then the third one, the third point in the resolution, was to the effect that the acting CJ has made a publication which directs that all cases should be brought to him personally to allocate. Look, even in these proceedings, at a point we went to court. One of the issues we raised in the court was that there is the empanelment. It was one of the issues we have even raised in these proceedings, that even the process of empanelment should be looked at. Now, GBA, which has sat down for all these years, now I think it's not even fair if I say GBA. The 45 persons, who supported this motion, have been in this country from how many years, and they are aware that these cases have been allocated personally. In fact, not too long ago, the current Chief Justice, who is on suspension, has actually made a similar, directive that cases in the Supreme Court, when they are filed, to be brought to personally to allocate, to assign. So this has been the practice. So what has changed that all of a sudden a group of lawyers who have been practicing in the court will decide that something like this should not happen? Yeah. So when you look at the 3-point resolution, I insist that the persons who now I no longer can say GBA, the lawyers who assembled to support and vote for this resolution intend to act lawlessly and unconstitutionally. From all the 3 things that we have said, it is clear that there's no desire to follow law. There's no desire to follow constitutional.
Let me put that to Xavier. Xavier, on all the points that the resolution touched on, I cannot find one single legal constitutional basis to support it, Xavier. I can't find it. I believe we lost Xavier. We'll try and get him back and to ask him that question, because I need him. Now he's clarified. And by the way, Justice, he actually says 47 lawyers voted for this particular resolution. So this resolution is the work of 47 lawyers. And that is the clarity you're getting. So if you're just joining us and you're wondering, the big resolution that has caused a lot of controversy, we now got clarity. 3 lawyers we spoke to say they all disagreed. They didn't get the notice ahead, but they've been clarified that it has been advertised for 2 weeks. But we also now understand that the mid-year conference is not something that happens that regularly. The last time it happened was 2022. So at least it's been 3 years since the last time it happened. So many lawyers, from the clarity I'm getting on the show, it's not something that they prioritize. And so when they were invited, many didn't go. And so you have 47 people just voting and adopting this resolution to represent an association of, several thousands. So that's the clarity going forward. Nonetheless, it is a resolution of the association nonetheless. And so that's where we are now. Xavier is back on. Xavier, do I have you?
You have me.
Good. And my question to you, I've just been looking at each of the points in the resolution, and I cannot find one single legal constitutional basis to support any of them. In fact, I find the contrary. I find legal basis to disprove and actually challenge the positions that have been adopted in this resolution. One, you say the Article 1296, and that that particular clause there linked to the Article 146, there should be regulations. And I've heard many of your own colleagues cite Rounds for France versus Electoral Commission. It has already been decided and determined on the matter that not every discretionary power requires a prerequisite of a published regulation for it to become binding. That has already been decided, but that I see it in your provision. Again, I see the point about the acting Chief Justice. It should revoke or reverse the decision and his memo that all cases should come to him to assign. And that is what all Chief Justices have done. In fact, it is their prerogative. It is in the acts and rules governing the judiciary. So can you point one single piece of legislation, constitutional or otherwise, that supports any of the points in your resolution?
Evan, thank you very much. Let me start with the circular by the acting Chief Justice.
Mm-hmm.
My reading of the circular creates the impression that every case, no matter where it's happening in the country, should come to his office. And that's where the difficulty is. I see some impracticality there. Probably, maybe the circular did not communicate the intentions of the Chief Justice's office, the acting Chief Justice's office. They're reading it, saying that all cases files should come to should be directed to his office for allocation of date and also court. I think that's quite problematic because it will not allow for the smooth running of the system.
But aren't you reading literally? I'm trying to look for the exact wording, but knowing the course, and when the Chief Justice says that, you know what it means. It doesn't mean that every case even to the circuit court be brought to him to
Evans, I must admit, personally, when I read it, I didn't understand.
But I'm not a lawyer. I think I have a fair understanding. When I saw it, I knew what he meant. I mean, he meant that some cases are obvious in terms of the appeals court, the Supreme Court.
Evans, that circular was not specific as to the kind of cases. Maybe you are.
I believe it may have said superior courts.
No. I didn't remember reading.
I will try and look for it, but yes. But I didn't get the impression that every case.
I don't remember reading anything like that.
But you know, he couldn't have meant that every case from the circuit court all the way to.
But if he had wanted to say Court of Appeal cases or Supreme Court cases, he would have said it.
Mm.
Now let me get back to the.
But even that, just a quick point. But even if that's what is meant, even that's what he meant, it is not illegal. It is a Chief Justice. That's his job.
We are not saying no. We never said it's illegal.
Yeah.
If you read it well, we never said it's illegal. The only time we used the word to discuss something was the suspension that it was unconstitutional in the whole of the document that we sent out.
Okay, prove to me. Prove to me that point is unconstitutional.
About the exercise of
the suspension. The suspension.
Because tying it to 296, we think that this is one of the cases in which there ought to have been regulations in the form of either a constitutional instrument or statutory instrument before the president could exercise his discretion to suspend the Chief Justice. Yes, you may say that Joseph France says that it is not in all cases, but it doesn't also specifically say that in this particular case it shouldn't happen. The fact that it says not all cases does not mean that in this case it should be so.
Yeah. But he doesn't say that. So how then do you determine that this is one of the cases that it must apply?
Because of the nature of the case.
What was the nature of the case?
This is about the removal of the Chief Justice.
No, it's not. It's not, Xavier. Xavier, this is not. Specifically, it is the suspension of the CJ, not the removal.
Yeah, it's about the suspension of the CJ. Yes.
Yeah, so those are two different things. This is administrative.
This is about, yes, it's administrative, I agree. I have also read Joseph Frank very well, which all the points my colleagues have made are valid. But what I'm saying is that it doesn't mean that in this particular case, involving the suspension of the Chief Justice, in which the President has a discretion to exercise, there must not be a regulation to that effect because of the sensitive nature of it. So we hold a humble view at that meeting by majority decision that justice is concerned in matters of this nature. There are in the nature of constitutional instrument or statutory instrument before the President could exercise his discretion in suspending the Chief Justice.
And Xavier, do you admit, though, that in the absence of the constitutional instruments that you talk about in the regulations, the President, having been confronted with this particular reality, can only operate based on the constitutional provision in front of him?
Can only?
Sorry, can you hear me?
I didn't hear the last part.
I'm saying that, do you admit, though, that what you're asking for doesn't exist now, as in the constitutional instrument that will guide this doesn't exist? In the absence of that, having been confronted with the facts and the petitions, the President could only have acted based on the constitutional provisions as he has now, as we have it down in the Constitution. And that's all he's done. Do you admit that that's all he could do?
In actual fact, that is what he's done by relying on the provisions in the Constitution.
Yeah, so there's nothing unconstitutional about that then?
But the meeting took a contrary view that, irrespective of those provisions, he ought to have still have a publication of regulations in the nature of constitutional instruments. Are
you suggesting he should have disregarded the constitutional provision?
No, he doesn't have to.
And aspire to hold on to regulations that do not exist?
No, but that is a provision that we saw he ought to have published. So we are not saying that he cannot trigger provisions under the Constitution.
Are you suggesting that
in as much as he could do that, he ought to have also have the regulations published before doing that?
Okay, so that's clarity. So you're saying that the President should have caused the provisions to have been published before suspending the Chief Justice?
Exactly so.
But that will
that
actually...
That is the position taken at that meeting.
No, but
by the majority.
But pause for a second and think about what you're actually proposing the President does. If he had paused and caused the constitutional provision to have been drafted, and the draft actually then gave him the authority to suspend him, you would have said he's manipulating the process.
Why would we have said so? Because he would have then satisfied the terms of Article 296 as members at our meeting on Saturday thought he ought to have done.
You're saying that he could have just, as a matter of formality, passed the constitutional instruments, and in there, they would have written in there, because if that's what he wanted to, in fact, that is the implied assumption in the provision, in the resolution. Written still in there that he can suspend the Chief Justice based on this particular evidence before him.
So if he had done that, I am not sure the meeting would have come up with this kind of resolution. Even though, according to you, he would have just done it as a matter of formality. They would have done it anyway. I'm not sure the meeting would have come up with this kind of resolution.
I mean, Justice Stremsai, he's offered some clarity and some explanations to back the decision of the 47 members of the association who took the decision. Aren't you convinced? Because 296, he says, is very clear that this is one of those instances where you needed a clear constitutional instrument or statutory instrument to guide. And the President should have done it before he did the suspension.
Evans, I'm not convinced at all, and this is why. France did not, I think there's even a misinterpretation of Rasmus France. In Rasmus France, the key question, when we read carefully, the key question was whether the refusal or inability to publish a regulation disable the person from exercising the discretion? That was the real question before the court. And the court held that the failure of the person to publish the regulation does not defeat the exercise of the power. I think that is the core decision there. When you look at it this way, then the question whether this particular one or that particular discretion should be preceded by a regulation, that issue doesn't even arise at all. That is why I'm not. But the bigger point is this. Even if, and you were asking a very important question, that should the president decide to do this regulation, that will take 21 days, because the process of making such regulation means that you have to draft it, it has to be tabled before Parliament, it has to be in the House for 21 days, for it to mature if it's not annulled. So that is the whole process. So for someone or for the 47 lawyers to actually expect that while this process is going on, the president will publish a regulation and say that if I want to exercise this power, this is what I have to do, that will still come back to the same point that the president has exercised his discretion to even publish the regulation. And even that means that you need to publish another regulation to guide your discretion to publish that regulation. So when taken to the logical conclusion, I am not convinced that it has any basis, the claim or that particular item on the agenda has any legal basis, especially when the court of law has made a pronouncement on that. In all this, I think that the GBA is squinting in the sense that just a few days earlier, they were emphatic in their publication that no one should interfere with the process. Let's all wait and watch what is going on. And the only time someone can, interfere or say something about the process is when the process is complete and you want to set it aside. I heard my very good senior savior on your show, and he was basically advising that all of us should restrain ourselves from commenting on the process and to respect the privacy of the process, because there's a constitutional command, to that effect. So if today, 2 days later, the same GBA on its letterhead is still saying that the outcome of the prima facie decision should be published, when we know, and the GBA earlier said that it should not be made public. So these are matters that should be disturbing every well-meaning member of the Ghana Bar Association. That a bar association which is most respected in the history of this country will be reduced to this level where it will be giving conflicting directives on serious national issues. But for me, I understand why this happened, but that is not something that we have not seen before. The main point here is that we at the Attorney General Department have advised the President on what the Constitution says he should do. As far as we are concerned, the President has followed that, religiously and strictly, and has not breached any of the rules. Yeah, we believe that going forward, we can have this conversation about how to amend the law and improve the system or improve the procedure. But to say that the procedure has been breached is completely not backed.
Yeah, and Justice, you touched on something I'm curious about. You say that you know why this happened. And I'm assuming when you said that, you meant you know why this particular resolution was adopted. Why?
Evans, I think that will not be something that would be appropriate for your listeners this evening. On another day, where the moment allows, I believe we can have that conversation. But let me just say that there's a misconception about the process. People are assuming that suspending the Chief Justice is punishment. It is not. He's still the Chief Justice of the Republic of Ghana. The process is still ongoing. I believe that the Chief Justice has what it takes, to defend herself rigorously, and refute any allegation, and have herself, reinstated, to perform the function of the Chief Justice. I don't think that suspension is a punishment in this context.
And Dr. Sai, very quickly because of time, your boss is a leader of the bar. We haven't heard him issue a statement or say anything about this. Considering that he's a leader of the bar, what is his view on this? And very briefly, does he plan to do anything formally about, now that you know it's 47 people, 5 against, a few abstained, does he plan to do anything, possibly register a formal protest, raise formal questions around this process that led to the resolution? What is the thinking there?
No, so my boss is indeed a member of the Ghana Bar Association. He's also the leader of the bar, but the bar is beyond Ghana Bar Association. There are lawyers who are not members of the Ghana Bar Association. So I don't think that my boss' position as leader of the bar has a direct correlation with what an association of the bar is doing. What I know my boss is more focused on is how to ensure that the process as is going on complies strictly with the Constitution. And he will be the last person to support any unconstitutionality when it comes to this kind of process. He has no desire whatsoever to issue a press statement to respond to what an association has done. Every association has a right and a right to freedom of expression, and they have their own rules that regulate their behavior. And we are all members. I am a member of the association, and I respect the view that was produced in the resolution. Just that I disagree with it, and I thought that it is something which is not backed by law. I think that is enough comment that anyone can do. And we also have to agree that the Bar Association is not a court of law. It is not a guarantee that anything that comes out of the Bar Association is legal or is constitutional or is sacrosanct. It's just an association which could also err as any other association has been. So we will take it in that side. In any case, we will consider the recommendations that have been made. And going forward, maybe we will add it to the things that we can do to improve the process. But for now, I don't think that the allegation that unconstitutionality has happened is founded. Is founded.
And Sylvia, very briefly, I mean, this must lead to something very concrete. You had proposals, you have a resolution, you're making calls. Apart from the fact that the president should revoke, there are fundamental constitutional questions there that are begging for some interpretation, for some closure. There are some of them that other lawyers believe has already been settled, but there are many more in this particular proposal. You just heard the Deputy Attorney General say, we will consider some of them. How does the GBA plan to proceed to getting some real concrete outcomes on the back of this beyond the controversies created? Because there's a constitutional review process ongoing. What's the thinking there? Very briefly, if you may.
I think that, as some people have said, this is novel. This is the first time it's happening under our Fourth Republic. So, if you recall, when clarity was brought to the process of appointing Supreme Court judge, when we went to court at GBA, that was when the court was clear that the advice by the Judicial Council is not binding on the president. In like manner, the president too cannot just prepare his own list. So, there's a possibility that we'll have to see clarity one day at the Supreme Court. But let me quickly say that regarding the statement we issued earlier in this resolution, it must be known that the conference of the Ghana Bar Association is the highest decision-making body of the association. So whatever you did earlier or had done earlier, and there is a meeting of the association at this conference, and a decision is taken, it overrides the first one.
Okay. Sylvia, thank you very much. Thank you very much also to you, Dr. Justice Trensai, and our 3 lawyers who joined us at the top of the hour, just getting a sense of ordinary members of the Ghana Bar Association, their reaction to the decision the association has taken. Enjoy the rest of your evening.